Hi, I'm attorney Megan Cook, and I want to talk to you briefly today about the idea of military disability retirement pay in the context of divorce. So people get really confused when thinking or looking at the resources available on dividing military retired pay itself. And then you add in the element of disability, and it gets, or can get, really confusing. So what I want to do is walk you through some basic things that will help guide you through figuring out your specific situation. Make sure to consult your own lawyer before entering final orders. If a service member leaves the military and they do so because of a disability, but they have not yet matured, that service member could leave the military and then know that they're not going to receive military retired pay, and then find out that they are disabled, and in that way they don't have an option. They would receive VA disability benefits. They would receive the check from the VA, and this check is 100% separate property, which is not divisible in a divorce case. That is not something a former spouse can receive, whether it's this scenario or whether they are vested in that they serve their 20 years and then they're retiring. Okay? So that's one idea to keep with you here. Disability benefits are separate property, and the federal government has been very consistent in finding that that disability benefit is not divisible. Where it can get confusing is figuring out what exactly is a disability benefit when you look at the pay stub or the RAS statement and you listen to the service member's specific situation. So let's talk about that a little bit further. Now, one thing to keep in mind is that a service member who is eligible to retire from the military and has accumulated military retirement can be given the option to waive some of that military retirement in order to receive a VA benefit. So as much a VA benefit as they receive, their disposable retired pay goes down. They offset one another depending on if it happens that the service member has the right to elect. If they elect, that's how it works. So the reason why a service member might want to do that is because VA disability benefits are tax-free, okay? And disposable retired pay is taxable compensation. So the service member may be inclined to want that VA benefit, but the former spouse, who has a right only to the disposable retired pay portion, does not want the service member to receive the VA benefit when it's an election. So you'll commonly see in orders a rule to the service member that if they're given the choice to elect a VA disability, they cannot choose it. They cannot make a choice to reduce the former spouse's right to receive disposable retired pay. So one way to make sure that's even stronger is to include an indemnification clause that says, listen, this service member cannot choose to waive disposable retired pay in the interest of VA disability, and if he does, then he has to indemnify her or him and pay that person back the amount they would have received if that waiver was not made. Okay? So language like that can make a huge difference in ultimately what happens. But sometimes language like that cannot be entered in a divorce case because it's negotiable, and sometimes it just can't be something that is either a court orders or that lawyers agree on at the time. And so it's important when entering these agreements or when the court makes its rendering that we understand the long-term consequences of the language being there or not being there in a divorce case. So another concept that is important to keep in mind is the fact that there's a type of military retirement that happens under Title 10, Chapter 61 of the United States Code that is essentially a special type of military retirement that occurs because of a physical disability. That type of military retirement that occurs because of a physical disability is definitely going to change the idea of how much disposable retired pay you're seeing on the RAS statement, specifically because the United States defines disposable retired pay to be such that the rating, the percentage amount of the service member's disability is put into a formula to determine what portion of their check is disposable retired pay and which portion of the check is disability. And so when you're looking at the RAS statement, it doesn't just tell you this portion is disability, this portion is not. You actually have to go and look at the specific formula that they put there in their definition of disposable retired pay, and you have to actually calculate from that check what amount is disability and what amount isn't. For Chapter 61 retirees retiring from the military because of physical disability, if their rating is 100%, meaning say the person has retired from the military not by any choice of their own, they are not able to serve, 100% rating means 100% of their check, of their RAS statement, of their pay is disability, and it's non-divisible in divorce, okay? So the only part left that the service member may divide in the context of community property is what's called CRDP, Concurrent Retirement and Disability Pay. That is supposed to be, it was legislated in order to make it so that this service member who served 20 years or more, who's retiring because of a physical disability and not getting any regular retired pay, any pension pay, only disability, is going to be paid back for that amount. It's going to be paid back. So CRDP is supposed to function to pay the service member back actual severance pay, actual pension pay. That CRDP amount is listed at the bottom of the service member's RAS statement. It says this is the CRDP amount in a message, and that CRDP amount is community property that's divisible in divorce, with this caveat. Presently, there's a lawsuit going on where the question of whether CRDP should be divisible in divorce or not is being addressed, and that lawsuit is not yet done. So it's possible that CRDP could be defined as also being separate property like disability that's not divisible. But right now, that unknown, though, makes this analysis difficult for somebody who's trying to figure out how much to offer former spouse fairly in a divide of military retired pay in this context. But the unknowns can make it so that the former spouse may elect that contractual alimony or some other asset should be paid because this is simply just not known enough to negotiate on properly. But the service member may choose during open season in January of each year, they may choose whether to elect CRDP, that special type of benefit we just talked about, or they may choose CRSC, Combat-Related Special Compensation. This is the type of benefit that can only be given to a combat-related injury, and it like disability, is 100% separate property. And if you receive CRSC, you cannot also receive CRDP. CRDP can serve to help the former spouse receive a part of the military retirement. CRSC cannot. So the election that the former spouse or that the service member makes can have major consequences to the former spouse, and also to the service member who stands to receive more, perhaps, if he can avoid or she can avoid paying their former spouse. This is difficult waters when we're going through a divorce case, because it means that the service member, and increasingly so in the legislation, is going to have a lot of control over what happens with his or her benefits and what doesn't happen with them after the term of divorce. So a spouse may think that he or she has a right in that amount and it plans on it as a part of their retirement, and it can disappear based on legislation that's occurring even now. So that's some of the information that can help you understand military disability benefits in the context of divorce. And I do hope that this has served to guide you today. Now, Thank you so much for stopping by, and we hope to see you again soon.